My name is Koziol, Legal Counsel to the National League of Fathers. Welcome to our website, welcome to our organization, and I've been asked by the Board of Directors of our organization and its executive staff to present for you an overview of some of the things that we're doing, in particular some of the lawsuits that we file and the resources that we're looking to acquire to help us in this mission. At the outset, it would appear that when we have a name such as National League of Fathers, that this is simply a father's rights group. It is not that. It is much more than that. The purpose of National League of Fathers is to unite children with their parents. When you have shared parenting in a co-equal, cooperative environment between parents, whether they be married, never married, or divorced, then you have a much better environment for children to be raised. The vast majority of our social ills today across the country that we throw so many tax dollars to can be traced to the absence of one parent from the lives of the children. It's become such an outrageous problem, so pervasive in scope, that we as taxpayers, as concerned residents, are finding it almost an insurmountable task to rectify. We believe in the National League of Fathers that the family structure, if it can't be maintained in an intact condition, that the parent-child relationship becomes paramount, much more so than the antiquated best interests of the child standards, which so many courts purport to be holding as their primary concern. As a little bit of a background, as an attorney, I've had 21 years of unblemished, successful track record working in civil rights principally. I've brought a lot of constitutional rights cases in various courts, federal and state. I've brought cases right up on writ of certiorari to the United States Supreme Court. I was able to have a declaratory judgment successfully asserted against a Indian Turning Stone casino here in central New York, the largest casino in New York State, and have its gaming compact declared unconstitutional. I have caused many rallies to come together that resulted in thousands of people rallying behind landowner rights, for example. I've also been on 60 Minutes. I've been featured on the front page of the New York Times. I've been on CNN. And in so many ways, in diverse civil rights cases, I've also represented women in sexual harassment and gender rights cases. So I bring to this organization a very diverse but very relevant background, because fathers' rights, the rights of fathers to bond with their children, remains, in my opinion, after so many years in the legal profession. I have stated, and will continue to state, that this is a form of discrimination which is pervasive, it is continuing, it is indeed the last vestige of institutionalized discrimination remaining in America today. In New York State, legislation that has been held up in the Judiciary Committee for some 12 years has a background. There's some legislative history to it. The legislation is supported by such statements, findings, conclusions that some 95% of custody determinations in New York State favor the custodial mother. 85%, U.S. Census statistic information will verify, 85% across America, child support obligers are men. Had that been the case in any public governing structure, that say 95% of men were in the government workforce, or 85% of the composition of General Motors were men, then I dare say that there would be outright riots and rallies in the streets seeking equal rights. But yet here, when in the court systems of states all across America, men are so invidiously discriminated against, we see very little happening. It is one of the most quiet forms of discrimination ever known to mankind. And it is occurring on a rampant scale here in America. National League of Fathers has as its mission an unbridled goal to rectify that problem. Unfortunately, too many organizations have come and gone. They have matured to a certain level. Fathers have gone back to whatever they do with their free time, and those organizations have disbanded, dwindled, or rendered themselves ineffectual. That's not going to happen with National League of Fathers. We've been growing in the short time we've been around to massive scales. And we have achieved much recognition nationwide. We've been on nationwide news programs, we've put out briefs, I've done an op-ed piece that has been considered for publication by various newspapers around the country. And we continue to put out work product that we've worked hard at. And we hope will change the landscape of parenting rights as we have come to know it in America today. What I have done is filed lawsuits in various courts in New York State. One of these lawsuits are at a middle level court of appeals. Several are at the lower state court arenas. And one I have filed, which I hope will be a landmark case, is a case that I filed in Albany, the state's capital here, against the chief judge, the unified court system of the state of New York, and the state of New York. That lawsuit, which we have circulated and is a public record document, is one that sets forth the principal position that we find unconstitutional, and that is the separate but unequal doctrine of parenting. States all across America are championing a separate but unequal doctrine of parenting, which is inherently unconstitutional. That particular doctrine finds its way in almost every parenting case that we see on a regular scale. To try to challenge this problem on a case-by-case basis, which I am doing with a number of clients, it is the long road, which will maybe perhaps never occur. Similarly, in the legislatures, much like when they tried to get the abortion right in, it was a failure to achieve any real success nationwide. Success was finally achieved through the courts. In the parenting cases, however, access to federal court is next to impossible. Between the various justiciability doctrines, the Rooker-Feldman doctrine, Younger abstention doctrines, and others, access to federal court, which is the principal guardian of constitutional rights, is nearly impossible for any person that finds themselves unfortunately dragged into a family court or domestic relations tribunal in any state. We must continue to access the federal courts wherever we can. But as the law stands now, it's going to have to be done through the state systems, or at least endeavored that way. It's a long road. You have to go an extra layer to get to the United States Supreme Court, and so few cases reach the United States Supreme Court. So much like fathers' rights groups, the cases that they bring are also falling to the wayside. The National League of Fathers is not going to allow that to happen. We have sued in a declaratory judgment action, a very profound and potentially landmark case, because the problems that lie here in the parenting problems of New York State are within the judiciary itself. That is to say, when 95% of cases are decided favorable to women, that is inherently an unconstitutional result. It is a disparate impact of a magnitude that has to be rectified, and it is a problem that can be corrected only by the court system itself. In this case, we're looking for relief in the way of studies that the High Court should undertake, administrative action that the High Court should undertake, removing such things as custodial, non-custodial frameworks among fit parents. To some degree, it has already been done. In a report by a 2006 Matrimonial Commission report given to the Chief Judge in New York State, some 72 pages of analysis was made, and the term visitation was dropped from usage in the New York State courts, although they are still being used today because it's become so commonplace as a term that I call a slur. Visitation is a slur, there's no question about it. I don't visit with my children, I don't know if you do, but we aren't visitors in our children's lives, and we are not facilitators in the way of child support. We are a component part of our lives. Our children require our presence. They need us. They're begging for our help. They are too young to know how to go about getting their fathers back in their lives. So we have duties. We have duties as men, we have duties as fathers. We must step up to the plate. Now, I'm talking about a baseball plate, I'm not talking about a buffet plate. I'm talking about the real plate that goes to the core of our existence as men and fathers, and that is to take charge of our children, to become leaders and respected persons in their lives, and not the kind of nimrods that you see, these moronic people that you featured on TV that show the father and the men as being some sort of lesser class person. The stereotypes that have been made of fathers and good men, good fathers today are unremedied. Very little is being done about it, and we aim to correct that problem as well. But what I'd like to do next is, among these lawsuits, the landmark case that I have filed, I'd like to explain to you what I mean by substantive due process, which is the mainstay of that lawsuit and ought to be a mainstay in any lawsuits that are brought by you folks all across America. For the most part, the lawyers that look at these types of problems